Welcome to the Supreme Court of the United Kingdom, where today we're hearing an appeal in the case of Gourlay and the Parole Board. The case is concerned with whether orders for costs ought to be made against the Parole Board in circumstances where a recommendation that they have made to the Secretary of State is overturned on an application for judicial review. Counsel for the applicant, Mr. Gourlay, is Hugh Southey, Queen's Counsel, and he is currently in the course of his submissions. So I'll invite Mr. Southey now to continue.
My Lord, thank you. When we broke, there were a couple of things I think that were outstanding. Firstly, I hadn't answered my Lord's question about the issue essentially of whether or not this was a question of practice rather than a question of law, and so should it be before the Supreme Court. If I may, my Lord, I think we'd like to address that in writing, and just partly because of pressure of time.
Yes.
I just to sort of as a sort of initial guide to where we are likely to go, we are likely to rely on Hunt and what was said in Hunt, effectively. But I think it's probably better to save that for something for a written submission, my Lord, if that's okay.
Yes, of course. And I mean, there may still be an argument that if the practice is objectionable on legal grounds,
yes,
then this court should say so.
Well, my Lord, exactly, and that's where we're going to follow from in relation to Hunt. I mean, ultimately, if the Court of Appeal is consistently believing wrongly or consistently approaching the matter wrongly on the basis that Davis sets down a binding rule, then the court ought to say that and then potentially look at the implications for this case.
Yeah. Very well. We'll wait patiently to see what you give us in writing.
Thank you, my Lord. Can I
also ask how long you would like to prepare your submissions?
I would ideally like, I think, for 10 days, partly because, because we need to sort out legal aid.
Yes.
Somewhat.
Yes. Well, you can let us know if problems arise. But right. if we were to allow you 10 days in the first instance, then Mr. Collins would also require an opportunity to reply.
Yes, obviously, yes.
And how long would you like, Mr. Collins?
I'd ask for the same time, my Lord.
Yes. Very well then.
My Lord, and as I say, we'll alert the court if there is an issue with legal aid, among other things. My Lord, can I then I think, obviously, given time, I want to try and move on to the second issue very quickly. Can I just, as a result, deal very quickly with sort of a few outstanding issues, really, in relation to the issue of Davis? Firstly, the Parole Board essentially say, identify a set of reasons for Davis, which are primarily the need for independence and neutrality, and the fact that, or the submission rather, that reasons should speak for themselves. Can I say immediately, we don't accept those are the reasons given in Davis, essentially, for that approach. So, for example, in relation to reasons, the court clearly was somewhat uncomfortable with the fact that the conclusion, or the result rather, of its judgment was going to be that coroners were going to be less likely to supplement their reasons. And that's consistent with, and I won't take the court to it, but if one looks at the Court of Appeal's judgment dealing with reasons, which is at Authorities 3, tab 24, page 182, memory stick 182, at para 24 to 25, they recognised essentially that although obviously judges should, wherever possible, provide complete reasons, there may be circumstances where it's in the interest of justice for those reasons to be supplemented after a judgment is reached, not least because it may then avoid the need for litigation. So we don't accept necessarily that there is any objection as a matter of principle to supplementary reasons, to use that language, being provided. In terms of independence, I think I've addressed that. The only reference I would also give the court, because it makes good a point I made, is to Mazar, which is in the Supplementary Authorities tab 85, and it's page 313 of the Supplementary Authorities, where at paragraph 108, the Court of Appeal made the point that I've made repeatedly, essentially, which is to say judicial immunity is primarily concerned with a claim against a judge personally, basically. And as I say, I mean, the reality is inconsistent really with the submissions of the Parole Board. The Parole Board does, for example, quite often join in litigation, or I don't know about often, but it can join in litigation. Nobody has suggested that's wrong. Coroners can join in litigation. Nobody suggested that's wrong. It just means that they are then potentially at risk of costs. Final point I should make is that the Parole Board also makes the point, essentially, that a prisoner in the claimant's position doesn't bear any costs. So from his point of view, there is no issue about access to justice. But of course, although on the facts of his case, he was represented and had no liability for costs as a result, even where someone's legally aided, that is not necessarily the case. An individual can, for example, be required to pay a contribution. And there are regulations governing contributions, and they are mandatory. So even somebody who's legally aided may ultimately end up paying for access to the court system. The legal aid regulations are the Civil Legal Aid Financial Resources and Payment for Services Regulations 2013. More importantly, they are in the supplementary bundle at tab 83, page 11. And so one can't assume that these principles essentially apply without cost merely because somebody's in receipt of legal aid. Obviously, also, there will be private paying clients. One can't assume that the Parole Board is only going to be subject to judicial reviews brought by legally aided clients. As I mentioned in passing this morning, Section 30 of the Legal Aid and Sentencing LASPO, it's always called, I've forgotten now the full name of it, which is Authorities tab 14, page 584. That makes it clear that you shouldn't be in a worse position, essentially, because of the fact you're in receipt of legal aid. And as I say, that probably reflects the fact that somebody who's in legal aid may pay contributions which they don't get back from the legal aid agency simply because they win their judicial review. They only get those contributions back if they receive costs. So moving then to the position in relation to the Parole Board. The starting point in our submission is that whether or not Davis should be seen as setting some form of rule, for all the policy reasons I gave, one should be cautious about applying that broadly. And the Parole Board's case draws attention to how widely Davis has been applied. For example, drawing attention to the fact it's applied to the Ombudsman, it's applied to coroners when there isn't a list. In our submission, even if Davis may make sense in some contexts, one should be very cautious about applying it broadly. And the Parole Board is one of the examples of a situation in our submission where one has to be very cautious about applying it. Now, the starting point in relation to that is to look at what the nature of the Parole Board is. And the Parole Board is an odd body in our submission. Its statutory function is set out, or its statutory basis is set out in section 239 of the Criminal Justice Act 2003, and that's in volume 2 of the Authorities, tab 11, page 446. And that makes it clear that the Parole Board, firstly, is a body corporate. Just mention that in passing because it deals with the point I made about personal liability. This is not a case where there's any suggestion of members being personally liable. It then has statutory functions conferred on it, and there it notes those in 239 subsection 1b rather of section 239. And those statutory functions essentially are all to do with liberty. They're to do with release and recall. But it also has a duty, and it's a statutory duty. It's not just a sort of discretionary power, but it's a duty to advise the Secretary of State in relation to any matter referred to it. And that, in some senses, is a very broad power. It is quite clearly an advisory power. So the Secretary of State is not bound by whatever outcome is reached. Equally, the Secretary of State doesn't have to exercise that power. Now, in practice, the Secretary of State often, I think there's no disagreement between the parties in relation to this, often exercises that power to seek a recommendation or to seek advice, essentially, as to suitability for open conditions in a case where a prisoner is also being considered for release. But there's no obligation for it to be linked to a release application. Equally, it's not all cases where release is an issue that advice is sought. There's been a lot of controversy about the Secretary of State's policy, essentially, in relation to prisoners who have previously absconded, and the Secretary of State changed his policy in relation to those prisoners, so that advice was no longer sought in relation to that group of prisoners. And so that does mean the Parole Board has this odd, in terms of a court at least, odd advisory function, statutory advisory function. But that reflects in our submission the fact that the Parole Board has its origins essentially as an advisory body. As the Court of Appeal judgment records, until 2003, it was the Secretary of State who would, that's paragraph 6 of the Court of Appeal's judgment, it was the Secretary of State who would decide whether or not a prisoner serving a life sentence should be released. That has had an impact on the functioning of courts and of the Parole Board rather, and one sees, as we made clear in our statement of case, in 2008, as recent as 2008, the Parole Board was found to lack independence when performing its function under Article 5. The authority for that, and I'll come back to Brooke for another reason, another more important reason in some senses, the authority for that is Brooke, which is Authorities 3, tab 35, page 133. And perhaps more importantly than the fact it was found to be lacking in independence, the cause of that was identified by the Court of Appeal as being the change of function from a body that was advising to a body that was had more judicial functions. More recently, and we included this in our statement of case, Core Authorities tab 5, page 390, this is 2015, the Court of Appeal noted a particular problem in relation to Article 5, again consistent with this background as essentially being an advisory body, which is that there is no power, certainly as far as we can see this continues to be the case, the Parole Board has no power to enforce its case management. And that makes it difficult, potentially, for the Parole Board to actively case manage cases to ensure compliance with Article 5.4. As I say, the reference to that is Vols, and it's paragraph 41 and 42 at Core Authorities tab 5, page 390. Now that history is important, as I say, for two reasons. Firstly, to make good the point I've already touched upon, which is the Parole Board, essentially, its origins are very different to those of a court. It is a body whose origins are much closer to those of an administrative body. But secondly, that's also had an impact on the way in which proceedings are meant to be conducted. If one goes to Brooke now, which is Authorities 3, tab 35, and the relevant passage, I think, is 1124. one sees Lord Phillips, who was at that stage Lord Chief Justice and presiding in the Court of Appeal, noting that one can't necessarily compare too closely the role of the parole board with the court, paragraph 43. First line in paragraph 43, then going over the page, same paragraph at the top of the next page, about 5 lines in, noting essentially that the function of the parole board needed to be considered in its historical context, and that was essentially assisting the Secretary of State. Noting at that stage, essentially the primary consideration of the Secretary of State was whether, and this is the first sentence in paragraph 44, a prisoner would re-offend if released. And that was all the context of paragraph 51. And I'd ask the court to read paragraph 51 now.
I wonder, Mr. Sally, if I could interrupt for a moment. There are obviously many ways in which the parole board is not like a court.
Yes.
In the most dramatic example that occurs to me was the chair of the parole board, Nick Hardwick, being forced by the Lord Chancellor to resign after the War Boys judicial review.
Yes.
And there's no way a judge would be told by the Lord Chancellor that his position had become untenable because of a decision of his being overturned, or even not even a decision of his, but a decision taken by the board. But is that really important for this purpose? In the feature of courts and tribunals, it seems relevant to Davies, isn't to do with institutional independence, for example, but it's the point which Lord Leggett focused on this morning, that they are carrying out a decision-making function in a neutral capacity, without any party pre-engagement in the matter, and that's why the general approach in Davies might be expected to apply to them.
Well, my Lord, the difficulty with that as a basis for deciding essentially whether Davies should apply is it's quite a difficult test in practice to apply. So, to use an example, the Secretary of State will often deal with categorization decisions, and will in particular often deal with Category A decisions. And Category A decisions have been recognized as being key decisions essentially for a prisoner, because you're in reality never going to be released if you're high security and Category A. And obviously in taking those decisions, the Secretary of State isn't a court, can't be said to be independent of the executive in any sensible way, but is of course equally required to act open-mindedly and not prejudge the matter and act in what might be described in a quasi-judicial way. And so there are rights, for example, to an oral hearing before in certain circumstances before the Secretary of State in those circumstances. And my Lord, that's the and the difficulty is, in some senses, what I'm really saying is that if you have a spectrum, and a spectrum may not be the right way of looking at this, but if one has a spectrum with one end, I don't know, the Supreme Court as the sort of ultimate arbiter of the law and required to be independent, and the Secretary of State as a Category A decision maker at the other end of the spectrum, somebody who's still required to be independent but is clearly administrative. The parole board comes somewhere along that, in the sense that it's not completely analogous to the Supreme Court, but is equally slightly different to the category A team. And in my submission, what's more valuable essentially is to recognize that these are important decisions that need to potentially be challenged, and look at in those circumstances whether or not, if there's an error on the part of the decision maker, there is any reason from distinguishing from the general rule. And the general rule, which would apply to the category A decision maker, is if you make an error, it may be in good faith, it may be that you've tried to do your best to get the law right, but you've made an error. If you make an error, you end up paying the costs of the judicial review, because the individual has the right to have that quashed. And the question really is there a sufficient basis for distinguishing between that sort of situation, where undoubtedly, as I say, you would be entitled to your costs if you successfully challenged it, and this sort of situation. And when looking at that, the fact that the Secretary of State essentially isn't a classic party in the sense of being a party to the lead, to the list rather, that is, I mean, that's one of the factors in our submission that needs to be taken into account. And what I was going to go on to say is that the added complication in relation to this is, of course, that in a situation such as this case, there is a particularly good reason potentially for the Secretary of State to want to stay clear of the parole board decision, because what the Secretary of State has done essentially is refer the case to the parole board, because the Secretary of State wants, one would assume, the independent expertise of the parole board in relation to the case. The Secretary of State, if the parole board comes back and says this is a prisoner who's suitable for open conditions, will have to apply their independent consideration to that recommendation, because they're an independent decision maker. They don't bind themselves to be to accept the recommendation of the parole board. And but it's quite awkward in many respects for the Secretary of State to be an active party in the litigation in those circumstances, where it's going to have to look at the outcome of the litigation. And that was a problem that was recognised as an authority in the bundles in Darwi, which is at volume 4, tab 45, page 1376. It's paragraph 80. And ask the court to read paragraph 80. What in my submission paragraph 80 recognises is that because of the statutory scheme, there's nothing inherently unlawful in the Secretary of State's officials essentially taking an active part in the parole board proceedings. But if you do that, you then have to have safeguards in place to ensure that any decision on the recommendation is fair. And the two safeguards that seem to be essentially identified are, firstly, essentially the Secretary of State has to be the decision maker, or someone who's independent has to be the decision maker, not the officials. And secondly, you then have to give an opportunity for the prisoner to effectively make further representations to balance out any submissions made by the officials. And that, in my submission, obviously does create a bit of a burden, and it may well explain why the Secretary of State is in one sense apparently reluctant to participate or doesn't participate on occasion in parole board proceedings, because of the fact the Secretary of State is ultimately going to have to potentially look at decisions of the parole board and reach their own conclusions. So one sees here, because of this sort of administrative function, one's quite a long way removed from the situation where one has a list. And it's closer to an administrative function. And clearly, if you're performing an administrative function, normally the expectation would be that you would get your costs if you successfully demonstrate, or you will end up paying costs rather, if you're shown to have sort of acted in an unlawful manner. My lord, that's the context in which the litigation strategy should be viewed, and the litigation strategy I've sort of alluded to, but haven't actually taken the court to, but it is an important document, and that's in the core volume, tab 6, page 404, core authorities rather volume. I mean, the litigation strategy was adopted on the 1st of April 2013, and to put that in context, up until that point, as the document records, essentially, the practice of the Parole Board had been to actively engage in judicial review applications, and one sees that at the bottom of page 404. Under the heading existing claims. And I should say nobody suggested that was objectionable. There's certainly, as far as we're aware, no judgment saying this needs to cease or anything along those lines. We have no evidence essentially as to why the litigation strategy was adopted. But it does. Sorry, my lord, I can't hear.
I don't think anybody's asking you a question, Mr. Shadi, at the moment.
Yes, I'm asking for. I'm still trying to find the bundle. I'm afraid it's page 404 of which bundle?
Sorry, the core authorities bundle. So it's the first authorities bundle.
Give me a second.
That is the memory stick page. Sorry.
It's the combined appeal document.
Yes. Yes. Sorry. I should say, just for clarity, the document actually starts at 398, but the passage I was referring to, which describes the historic practice, is at 404.
No, I'm sorry. This seems to be the decision in this case.
It's MS 404 in the main bundle.
Yeah.
Right, got it. Thank you very much.
Sorry, my lord, I'm not sure if that was my fault, but as I say, that you'll see under the heading existing claims, and that describes what the Parole Board's practice used to be until 2013, which was to engage essentially as other public authorities would do in a judicial review. And I was saying, when this was introduced, this was introduced on the 1st of April 2013. We don't really have any evidence as to why it was introduced. What I would say is, as I say, nobody suggested it was undesirable for the Parole Board to play an active role up to 2013. There is no judgment saying this is unhelpful for the court, or this is burdening the court with unnecessary submissions, or anything along those lines that anyone's been able to identify. In 2013, then, as I say, the version of the litigation strategy, and it has changed a little, was then adopted. And the key passage essentially is at page 399 of the bundle. Which adopted an approach, apparently, because it refers to it, influenced by Davis, and certainly we would submit that the sense of this is that the Parole Board wanted to reduce its budgetary exposure, or the amount of money it was spending on costs. And the approach adopted essentially was to firstly consider essentially whether or not it wished to concede. An approach one sees that in the first of the bullet points towards the bottom of the page, an approach we would submit that was consistent with the pre-action protocol, which is in fact set out in the next page, and the need to avoid unnecessary expense. If it decided not to concede, there were two options essentially. It wouldn't normally defend a decision in relation to early release or recommendation for open conditions. Slightly oddly, at that stage, it would defend other judicial decisions because it defines judicial decisions at the top of the page. And so, for example, it would defend decisions not to hold an oral hearing. And it would also defend claims for damages because the Parole Board has had a number of claims for damages based on delay, contrary to Article 5.4. Now, the critical point about that is that, firstly, whenever the Parole Board essentially applied this policy in our submission, and whenever it continues to apply this policy, it is, to some extent, expressing a view on the merits, because it's deciding whether or not to concede. If it thinks there's a meritorious challenge, it accepts it should concede. So it is implicitly expressing, and it's doing that effectively through a second decision, a decision as to whether or not to conduct the litigation, or whether or not to concede the litigation. Secondly, it's not suggesting there that it should never engage in litigation. And reference has already been made to the War Boys litigation, and we see the War Boys litigation. It's for some. It's essentially saying we're going to exercise a discretion. The normal rule is we're not going to engage in litigation, but it doesn't specify when it will engage in litigation. And the only factor that seems to be identified is that of cost, and it doesn't, for example, identify matters such as the public interest. And in our submission, what's clearly recognised is that there is potentially a public interest in a specialist body like the Parole Board participating in litigation. That was said in Davies, for example. It was said in Touche, and that isn't identified as being a potentially relevant factor. And all of this in our submission effectively suggests that the Parole Board is acting in many respects as other administrative bodies do. It is adopting a policy essentially which on the face of it appears to be intended to serve its own interests as a body, and it's adopting that policy to guide it in response to litigation. The policy has changed, and one sees that the next tab, which starts at page 405, is the current policy. It's very similar, essentially, to the previous policy, save that the apparent anomaly, essentially, in relation to judicial decisions is removed. So now the presumption is that the Parole Board won't participate in challenges to judicial decisions. But as I say, we do submit that what the policy demonstrates essentially is the Parole Board making policy decisions essentially to apparently reflect its own strategic interest, not taking account of public interest matters. And one sees that in DSD, which is the War Boys case. That is at volume 4, tab 39, page 1196. My learned friend points to the fact that the divisional court rather indicated that the War Boys case was an exceptional case, and it certainly did at Para 3, but they weren't matters that related essentially to the reasons given by the Parole Board for intervening. The reasons given by the Parole Board essentially are at para 84 of the judgment. Learned friend. And they were essentially, in order to address the board about important issues of, in order rather to address the court about important issues of broad approach, and because of specific criticisms made of the board's finding and the conduct of the hearing in this case. Well, that second reason, at least, is likely to apply in most judicial reviews. Now, I'm not suggesting that it wasn't a good thing for the parole board to participate in the Warboys case. Clearly, there was a real concern about the parole board's decision in relation to a serious offender, and the court was likely to be assisted by the expertise of the parole board. But there are other lower profile serious offenders where the public interest is the same. The public interest in getting parole board decisions right is obvious. You don't want to keep prisoners detained at huge cost if they can be released, but you equally don't want to have prisoners released who are going to commit further offences. And that, in my submission, is why there can be real value, as the Warboys case may demonstrate, in the parole board participating. The problem is that the application of the Davis case, as the parole board's litigation strategy demonstrates, actually it provides an incentive not to participate. Now, the part of the Secretary of State's answer to this is to say, or not the parole board's, not the Secretary of State's answer, the parole board's answer is to say the Secretary of State should always be a party to the judicial review. At least two points I'd want to make in relation to that. Firstly, the fact, even if that were correct, that the Secretary of State could be made an interested party or should be made an interested party does not necessarily mean that costs should be awarded against the Secretary of State. If the Secretary of State is neutral on the judicial review, as the Secretary of State may well be, because of the Hindawi points, etc., why should the Secretary of State essentially end up paying for the costs of a decision that the Secretary of State isn't responsible for? I mean, the most recent authority on interested party costs, essentially, that we're aware of, was Fakiri, which is the case I mentioned in passing this morning, which is one where Davies was upheld. That's in the core authorities tab 2, page 343, which is, and it's paragraph 51 onwards. And what essentially happened in that case was that the Court of Appeal said you could award costs against the Secretary of State in an asylum case where there was a challenge to, I think it was the first tier tribunal, because essentially the Secretary of State was the opposite party, because the Secretary of State essentially was opposing the grant of asylum in that case, which is what the appeal was about. Well, that might work in the context of that case, but of course in a case like this, where the Secretary of State, perhaps for understandable reasons, has shown no interest at all in the in participating in the parole board decisions, much more difficult to apply that approach in our submission. And the second point we'd make is that my learned friend draws attention to Davenport, which is a decision of a decision subsequent to this decision of Mr. Justice Walker, holding essentially on the basis of a concession that the Secretary of State should always be a party to judicial reviews of the parole board. That's volume 4, tab 38, page 1181. And that's a case, unlike this case, concerned with release. And it was based, as I say, Mr. Justice Walker drew attention to the fact that there is a provision in the practice direction for judicial reviews that indicate that where proceedings relate to a court or tribunal, other parties to those proceedings should be named in the claim form as interested parties. The page is 1182 and it's para 13. The point I'd wish to make, though, about that, I mean, as I say, and that was then it was conceded that there'd been an error there by not serving, and that's para 14 and 15, is that Mr. Justice Walker went on to consider the public interest, essentially, in involving the Secretary of State. And that's at para 19 and 20. And I just asked the court to read those. Well, the point I'd make is that the first point made by Mr. Justice Walker is that the Secretary of State for Justice safeguards the public interest, essentially, by ensuring that any assertions made by claimants are properly examined. Well, in our submission, in a case like this, where the Secretary of State didn't attend the parole board for understandable reasons, the Secretary of State is actually not in a terribly good position to do that, to perform that role. It's the parole board that's in a much better role, in a much better position to perform that role, because it's the parole board that will know if there's anything that's said effectively about what happened at the hearing or something along those lines that is inaccurate. And similarly, in terms of para 21, the idea that, for example, someone needs to draw the attention of whatever of the parole board to whatever went wrong, it's much better in our submission if the parole board is aware directly of what went wrong. And so all of those points suggest that it's much more effective, essentially, for the parole board to play a direct role in circumstances where, as I say, the parole board itself doesn't suggest it can't play a direct role or it shouldn't play a direct role. It recognises in its policy it can play a direct role, and it does from time to time. See Warboys, see DSD.
In the sort of proceedings we're talking about before the parole board, the parole board receives a great deal of information about the progress or lack of it of the prisoner, his response to any training he's undergone and so forth, from usually employees of the prison service, which is an executive agency of the Secretary of State for Justice, or it may be people within the Ministry of Justice at a more senior level, depending on the type of prisoner we're dealing with.
Yes,
the Secretary of State will have, people answerable to the Secretary of State will have been participants in the hearing, and at the end of the day, the decision is of the board is one that is directed to him.
Yes, well, my lord, that's correct. But what I'm talking about is where you're looking at those sorts of points that are made by Mr. Justice Walker in Davenport. Mm-hmm. I mean, to use an example, a challenge that's sometimes brought against the parole board is to say all the witnesses, when they came to the hearing before the parole board, were agreed that this prisoner should progress to open conditions. They gave evidence to that effect, and the decision doesn't properly record that. Right now, the parole board will have, because it's effectively holding a hearing, it will have recorded have a record, and it will be in a position to say, we agree that's what happened, but we don't think this is unlawful, or we don't agree that's what happened. Here are our notes. This records what this witness said. The Secretary of State is, if responding to a judicial review, is having to contact prison staff who are there not primarily to present a case or act as representatives or things, who are there essentially to act as witnesses, and having to say to witnesses essentially what happened at this hearing, what's the position in relation to that, And that's why I say the Secretary of State's just not in as good a position, essentially. Of course, the Secretary of State can perform a role based on witnesses' attendance and things, but it's not the Secretary of State is unlikely to be in the same sort of position as the Parole Board. The Parole Board is in the best position to say, actually, this is a correct record of what happened, but we don't agree there's any illegality for these reasons, or whatever, or no, we don't agree that's correct. So that's why we would submit that. And a basic point I'm making is that ultimately the Parole Board is in a better position to safeguard the public interest. So, my Lord, in summary, what we say is that Davies, for the reasons we identified, should be narrowly applied. The Parole Board essentially is a body that has its origins essentially as being an advisory part of the executive. It still has elements of that in the way it functions. It is not a classic court. The Secretary of State's role is likely to can be quite often limited. In light of all of those things, the public interest is actually served by the Parole Board participating, but also paying costs when it errs. My Lord, I think that probably covers everything I need to say. Can I just check that there's no WhatsApp messages to me from those who are behind me, metaphorically? My Lord, I'm going to assume there's no messages. Unfortunately, I'm told that one of the difficulties with this case is that those who are assisting me and watching me and working with me actually get the feed a little bit later than I've had a message confirming there's nothing.
Thank you very much, Mr. Suffolk. Mr. Collins.
My lord, my lady, can you hear me?
Yes, we can. Thank you.
Grateful for that. I fear that was my fault. I was trying to unmute myself while those in charge of the broadcast were doing so. So every time they unmuted me, I remuted myself. I'm sorry about that, my lord. Clearly, there are two principal issues here. Firstly, what is the status of the board, and in particular, is it a court? And secondly, how does that status affect a decision on costs in a claim against the board? But those issues of principle have to be decided in the context of this case. And I'd like to begin, if I may, by dealing with that context. I should say that what I propose to do this afternoon, my lord, is to make submissions on the assumption that this is a matter which is appropriate for hearing by the Supreme Court. Mr. Southey's done likewise, and we'll deal, as my lord's indicated, probably in writing, but I'll take instructions this evening to see if those who instruct me have a different view. My provisional view is that we'll respond in writing, as the court's invited us to do. What I wanted to observe by way of introduction is that in some ways we respectfully suggest it was perhaps an odd decision to bring this claim against the board at all, and it was a wrong decision not to have the Secretary of State for Justice either as a defendant or an interested party. Some of those concerns have been highlighted by one or two questions asked by my lord, the Deputy President, this morning. Many of the concerns expressed by the appellant about the way in which the judicial review of parole board decisions operates and is funded are answered, we say, and would have been answered in this case by the identification of the correct defendant. Can I start with the way the appellant puts his case? And this was said in the case, paragraph 6A. I don't ask the court to turn it up for your notice, page 78. The appellant never sought release from the board. His was never a release case despite him being long post-tariff. He said the same to the High Court. And with respect, we say that's not right. Can I ask the court to look at the claim form, which is in the core bundle behind tab 9, page 192. That's 192 of the EF numbering. The claim form starts at 192, and at 193 we find details of the decision to be judicially reviewed, and in the box in section 3, the decision of the parole board refusing release and not recommending open conditions. So there's a reference there to release. And if the court can look at page 199, where we see the grounds for judicial review, paragraph 1 identifies 2 separate decisions in the last 2 lines. Roman 1 did not direct the release, nor 2 recommend transfer to open. And paragraph 2, the claimant applies for an order quashing the decisions, plural, and or for a declaration the decisions were unlawful because they were in breach of the rules of natural justice. And one can see in the last line of the paragraph reference to the 2 decisions made. And just finally, page 202, paragraph 18, claimant, the grounds of claim state in terms the decision not to release the claimant was unlawful. And at paragraph 19, further, or in the alternative, the decision not to release the claimant was unlawful for further reasons. Doesn't for these purposes matter what the reasons were. And the conclusion at paragraph 22, the court is asked to quash the first decision, that's the release decision, or in the alternative, the second decision, the transfer decision. Now, it is apparent from the judgment that at the oral hearing, the focus of the claimant's case was limited to the transfer decision. But of course, there was nothing to tell the board that that would be so from the grounds, nor indeed does that appear to have been before the judge who granted permission. Page 206 for your note. So we say the appellant is wrong to say that he succeeded before Mr. Justice King on precisely the argument he put before the board in his grounds. He succeeded on one of them, but appears to have abandoned the other. Now, where does that take us? Well, in one sense, not very far, because it wouldn't have affected the approach the board takes to litigation of this sort, because the board takes the same approach to decisions on release and transfer for the purposes of judicial review. And of course, we say this case is one illustration of how release and transfer decisions are, in most cases, almost inseparable from one another. And they're 2 sides of the same coin. And that's a submission I'm going to expand on in due course. But insofar as the appellant seeks to argue that a decision on transfer must be treated differently from a decision on release, in fact, to put it more accurately, judicial review of a decision on transfer should be treated differently. It's right, we suggest, to recognise that this was not, as the appellant suggests, a case which was only about transfer. But if it's right that what the appellant really sought to challenge was the transfer decision, then we respectfully submit that he went about it the wrong way. It's not in dispute between the parties that a decision on transfer is a decision for the Secretary of State. And can I ask the court, just so that I can make the submission clear, to look at Gilbert, the case we rely on. It's tab 42, page 1280. On the EF number, a case about the Secretary of State's policy on the transfer of prisoners who abscond from release on temporary licence. And the relevant passage is at 1305. paragraph 70, the discretion enjoyed by the Secretary of State in relation to seeking advice from the board under section 2392 of the 2003 Act. That's the section which provides that it's the duty of the board to advise the Secretary of State with respect to any matter referred to it by him to do with the early release and recall of prisoners. And transfers to open are considered to fall within the scope of that subsection. To be contrasted with the obligation he has to refer cases to it periodically to consider applications for release on licence. The Act confers a discretion on the Secretary of State whether to seek advice or not. And the fact that it refers to advice rather than mandatory directions underlines the discretion enjoyed by the Secretary of State in this regard. He's not bound to follow the advice. At paragraph 71, the court notes that the Secretary of State and his department and its agencies are also experts in the management of prisoners and the prisoner state, including assessing prisoner risk when it's relevant to the wide range of decisions which such management may involve. A little further down the same paragraph, if in light of the Secretary of State's policy, he doesn't consider it helpful to refer cases, that's lawful, doesn't deprive the board of any function. And then just finally, 73 at the bottom of the page, the Secretary of State has the relevant discretion whether to transfer to open conditions. He can promulgate his own policy as to how the discretion should be exercised. He has a discretion whether to seek advice from the board. Even if he seeks his advice, he's not bound to follow the advice, provided there's sufficient good reason not to. And if the advice given by the board fails for whatever reason to take into account the relevant policy, that may constitute a good reason not to follow it. So if the error of law about which the prisoner complains is confined to the question of advice on transfer, of course the prisoner is entitled to say that the Secretary of State should reach a different decision, and he can rely on the board's error of law in explaining why he should do so. He can indeed seek judicial review of the Secretary of State's decision. Now, my learned friend sought to suggest that there might be some difficulties in doing that. He was asked by my Lord Lloyd Jones once or twice, I think, whether there was any legal impediment to bringing a claim against the board. And we respectfully suggest that there wasn't a convincing answer given to that question. The answer is there's no reason whatsoever. Time limits can be dealt with. One would expect that a decision from the Secretary of State would be chased up if it wasn't forthcoming within 3 months, and in particular in circumstances where particular submissions were being made to the effect that the board had got the law wrong. And in case there's any doubt about whether it's a permissible approach for a prisoner to challenge the Secretary of State's decision not to allow a transfer to open conditions, with an authority in the bundle, it's Kumar, tab 47, page 1417. This was a case of the board making a positive recommendation that the prisoner be transferred to open conditions, and where the Secretary of State exercised his discretion to depart from the board's recommendations. I can ask the court to look at 1426. Paragraph 54. Whilst the Secretary of State's discretion to reject a recommendation by an expert panel, which has had the advantage of seeing and hearing witnesses at an oral review, must be exercised in a manner that pays due regard to those advantages and to the particular expertise of that body, it does not follow that fairness demands the discretion should only be exercised in circumstances in which the recommendation would be liable to successful challenge in the courts by way of judicial review. To do so would be to unduly fetter the discretion of the Secretary of State. Cases such as Banfield make it plain the Secretary of State may lawfully disagree with the Parole Board's view. Built into that is the presumption, if I can put it that way, that where the recommendation of the board would be liable to successful challenge in the courts by way of judicial review, that's an obvious case in which the Secretary of State may choose to take a different view and might perhaps be expected to do so. On the next page at paragraph 59.
Sorry, can I just ask, Mr. Collins, you say he may be expected to do so, but what if he doesn't? Is his decision then unlawful?
Well, my lord, it depends on the reasons that the Secretary of State gives for his decision. If the reasons rely upon a decision which is itself unlawful without more, then that decision will almost inevitably itself be unlawful. If the Secretary of State, for example, takes into account the matter which the Parole Board had failed to take into account, properly reflected in his reasoning, and reaches the same view, then that would be a lawful decision. So it will depend on the circumstances. But
no, thank you.
We've not seen anything different in the present case, for example. The other part of the case I was just going to ask the court to look at, paragraph 59, which is a question about whether the prisoner was required to be given an opportunity to make further decisions. And the court's view was that that would confer no advantage because the Secretary of State would be unable to fill gaps in the board's reasoning or provide a justification which the board itself had failed to provide. The last sentence of the paragraph provides the prisoner has adequate safeguards in the form of an ability to seek judicial review of the decision of the Secretary of State. So if it's the appellant's case that one can't pursue the Secretary of State in the present circumstances, we respectfully submit that is wrong. In a pure transfer case, the reality is there is no need to have the Parole Board as a defendant at all. So insofar as the defendant contends that the application of the Davis approach to the board in some way hinders access to justice in respect of transfer decisions, leaving aside the reasons of principle why we say that's wrong, we say the contention is answered by the simple fact that the claim can and should be brought against the Secretary of State. And of course, the Secretary of State is not a court, and the usual approach to costs is taken in judicial reviews of his decisions. But in most cases, it's fair to say that advice on transfer is given in the context of a decision on release. I won't ask the court to turn it up, but can I give you a reference? One of the cases in the authorities bundle is a judicial review by the Howard League about the removal of legal aid from, amongst other things, pre-tariff parole board reviews. The bundle reference is tab 46, page 1387, and at paragraph 57 on page 1398, the court noted some evidence from the board, which was that a pre-tariff review, that's a hearing where release isn't possible, so the board's only considering a move to open conditions, represented somewhere between 1.5 and 1.8% of the board's workload. So much the majority of cases involve a decision on release and a decision on transfer. And so, of course, I need to address you on the position of the Secretary of State in cases where the board has considered both of those matters. Now, firstly, if the prisoner accepts the decision on release but wishes to challenge the decision on transfer, we say the position is the same as that I've already identified. Defendant should be the Secretary of State. But where the challenge is to the release decision, either on its own or with the transfer decision, the Secretary of State should always be an interested party, and you've just been taken by my learned friend to the case which sets that out. That's Davenport, decision of Mr. Justice Walker, tab 38, page 1179. My learned friend said, or described it as a decision reached on the basis of a concession. I'm not sure it's quite fair to describe it in those terms. It's specifically described as a practice note at the head of the report. So it's plain that Mr. Justice Walker didn't simply accept the concession, but gave some thought as to what the right course of action was. You were taken, I think, to paragraph 13. On the way there, can we pause, please, at paragraph 7 on page 1182, just to highlight the point which I'm sure the court is aware of, and certainly it's in our case, that the parole board rules provide, those are the 2016 edition, but the versions which came before and after that say the same thing. The party identified in the rules means the prisoner or the Secretary of State. So the Secretary of State.
Which page are you on, Mr. Collins?
It's 1182, paragraph 7, my lord.
Oh, thank you.
Page, I'm sorry.
No, I think it was my mistake. Thank you.
You were then taken to paragraph 13 at the bottom of the page. And one can see there why I stopped at the definition of party, because Mr. Justice Walker identifies paragraph 1 of the practice direction, which states that where the claim for judicial review relates to proceedings in a court or tribunal, any other parties to those proceedings must be named in the claim form. So the party, the Secretary of State is a party and therefore must be named in the claim form. Assuming that Mr. Justice Walker is right, and that will be part of this court's decision to identify the parole board as a court or tribunal. And then on the following page, 1183, the passage which starts at paragraph 17, and you've been taken to most of this already, so I won't take too much time over it. But at paragraph 18, His Lordship identifies the importance of giving careful consideration to the identification of interested parties. The role of the Secretary of State is particularly important because, as my Lord President identified, it's the officers of the Secretary of State who will be engaged in compiling the dossier, as it's known, which is the collection of documents which are put before the board and really forms the bulk of what the decision must be based on. And those will be officials working within largely the prison and probation service. That may include prison psychologists and so on. But all that information comes from the Secretary of State. Where does that leave us? Well, it tells us that the Secretary of State should always be a or the defendant in a case of refusal to transfer to open conditions, should be an interested party in a case of refusal to release, and where the challenge is to both refusal to transfer and refusal to release, will be a defendant and be able to make submissions in relation to both issues. So in all three situations, the Secretary of State should be involved. Costs against the Secretary of State will be considered with no need to have regard to Davis in those circumstances. And because we say this is a claim which should have been brought against the Secretary of State, that has some significance because the fact that costs were not awarded against the board can give rise to no unfairness in those circumstances. So my lord, my lady, that's the context which I wanted to set my submissions in. Having done so, I turn to the issues of principle. And I'm going to do it, if I may, the other way round from my learned friend. So I'll respond first to the submissions that he's just made about the status of the board, and I'll come on after that to look at Davis. My lord, my lady, have the a relatively detailed description of what the functions of the board are in our case. I don't propose to go over those. What is established beyond doubt, we submit, is that the board must operate as a court for at least certain of those purposes, and most importantly, perhaps, for the purposes of Article 5.4 of the ECHR. That is, the right to take proceedings by which the lawfulness of detention shall be decided speedily by a court and release ordered if detention is not lawful. Can I ask the court to look at the way that was dealt with by the Court of Appeal in this case? The judgment is behind tab 3 in the core bundle. It starts at page 150, 150. But the relevant passage for the purposes of this submission is at 154, paragraph 18. I'm so sorry, paragraph 14 to begin with. No, it is 18. I'm so sorry. Thought in my note there. Paragraph 18. Lord Justice Hickinbottom the court may already have seen, undertaken an analysis of the progressive change in the role of the board to become the decision maker. And in fact, one can see right at the end of paragraph 17 that in respect of the decision to release a life prisoner on licence after the expiry of his tariff, the primary decision maker is not the Secretary of State, but the board, relying on West. And then paragraph 18, there's no mystery as to why that is so. Article 5 is cited. And under Article 5.4, His Lordship notes that following expiry of the tariff, a life prisoner who is then being detained solely until the risk he poses to the public has been assessed as being appropriately low to allow release, is entitled to take proceedings before a court to determine whether his detention is still lawful. And following the 2003 Act, it is the function of the board to act as such a court. His Lordship there refers to the case of West, and we have that in the authorities bundle behind tab 62. It starts at page 1678. Can I ask the court to start at 1691? Which is within the opinion of Lord Bingham. Article 5.4 is addressed at paragraph 37, and His Lordship says this: it's accepted that for the purpose of revocation proceedings, the parole board has the essential features of a court within the meaning of Article 5.4. Although it can only recommend the release of a recalled discretionary sentence prisoner, its recommendation has the effect of an order, since the Secretary of State must give effect to it. And then there's some detail about the functions which the Convention requires. And in the last few lines of the paragraph, His Lordship says the parole board is empowered to discharge those functions. Its review will, in my opinion, satisfy the requirements of Article 5.4, provided it's conducted in a manner that meets the requirement of procedural fairness, which he had earlier discussed. Just one other passage from this case, that's Lord Hope at page 1702. Within paragraph 81, paragraph that starts on the previous page, but the passage that I've asked the court to look at is just above B on this page. When the appellants were recalled to custody, the requirements of Article 5.4 would have been satisfied by the review of their recall by the parole board, which, due to its independence from the executive and its impartiality, has the characteristics of a court for the purposes of that article. One last case in relation to this issue, a Scottish case called Brown and the Parole Board of Scotland, tab 23. It starts at page 768. Can I ask the court to look, please, at 795? My Lord Reid may no doubt recognise that the passage, paragraph 61, the fact that the prisoner's detention during the extension period has not been ordered by a court but depends on recall by the Scottish ministers means that it must be supervised by a judicial body. And if one goes down to just above H, judicial supervision of detention during the extension period is necessary under Article 5.4. see Giles and Sim. The requirement of judicial supervision is met by the provision made by sections of the 1993 Act for reviews by the board. So there's in reality no serious question over the proposition that the board is a court for the purposes of Article 5.4 when considering release, subject to some submissions that my learned friend has made on independence, which I'll come back to if I may. But the first point that the appellant makes, to which I need to respond, is the suggestion that a recommendation on transfer must be treated differently. And the suggestion is that even if the board is a court when giving one part of its decision, it ceases to be treated as such when giving another part of its decision. And we say that approach is artificial and wrong. And we say the trial judge in this case, Mr. Justice King, took the right approach. I can take the court to the passage of his judgment where he deals with it. It's tab 5 in the appendix, page 172 is where the judgment starts. Can I ask the court please to look at page 185, paragraph 10. Can I ask the court to read that to yourselves?
But there is a slight risk of confusion if one talks about acting in a judicial capacity in a general sense, in a sort of constitutional law sense. And there's no doubt the board, in principle, ought to meet the requirements of Article 5.4. But it's not the sort of judicialized tribunal that one sees, for example, in the FTT or the upper tribunal. And an Australian judge, for example, asked to apply a constitution with a strict separation of powers would probably consider that if the board had a function where it wasn't taking a final decision, but was simply providing advice to the executive, that would probably disqualify it from being a judicial body under that kind of approach to the separation of powers. So the only point I'm trying to make is that we have to pay pretty close attention to the particular context.
My Lord, I respectfully agree with that. There are all sorts of examples in public law decision making of a description of the decision maker taking a judicial approach, which is to weigh fairly all of the information and reach a decision which can properly be reached on the basis of the law and the facts. And plainly, I need to show you something more or different from that. I understand the appellant's case to be, well, it's no different from the sort of judicial decision making undertaken by a Secretary of State, for example. But we say there is something different here. We are in a slightly different constitutional context than the Australian judge that my Lord identifies. We don't have in this jurisdiction a fixed definition of what is a court for all purposes. Different cases look at what is a court for all sorts of different reasons. But I hesitate over the suggestion, nevertheless, that what the parole board does is in some way less judicialized than what a first-tier tribunal does, at least as far as the vast majority of its functions are concerned. The transfer decision, I accept, is a little different in nature from the decision of a first-tier tribunal, because a first-tier tribunal's decision is to a degree at least, binding, although I'm going to come on to look at some decisions which have been held to be judicial decisions within the classic meaning of that expression, court-type decisions, even though they're not of themselves binding. But what the parole board does on a release decision can't, in reality, we would suggest, be distinguished from what the first tier tribunal does in an immigration or a social security context at all.
Well, there's quite a big difference between the post-legate tribunal system and the pre-legate tribunals, which would have fallen within the scope of Davis, which is a pre-legate case. It's a world which you're probably too young to remember. But if one was doing in those days a social security tribunal hearing, for example, you went to the office of the DSS, and that was where it was held. And the DSS would give all sorts of instructions to the tribunal as to how the hearings were to be conducted and what were policies to be followed and so forth. And nobody really thought terribly hard about Article 6.1 in those days. And
well, yes.
There's been a complete change in approach. And equally, with the parole board, if you read between the lines in Brooke and in Osborne, there's quite purposive guidance being given there to the parole board to what it has to do if it's going to fulfill the requirements of Article 5.4. And the guidance is being given because of the risk that because of its institutional relationship with the MOJ, it might not otherwise necessarily meet those standards.
One was absolutely right. There has been an evolution in all sorts of different tribunals, including the parole board, in the way in which they have been viewed. So the social security context is not one that I'm familiar with. Criminal injuries compensation is a field which I'm very familiar with, and I recall appearing in front of the board many years ago in an entirely different environment and process than one now sees in the first tier tribunal, whose decisions are, through a quirk of statutory creation, subject to judicial review in the same way that those of the parole board are. The parole board has similarly gone through an evolution, and one can see that there is a learning process which has gone on through Brooke and Osborne. Maybe when I come on to talk about the litigation strategy, one can see the board recognising that change in its status and the need for change in its approach as a consequence for it. The question, of course, is where we are now, or perhaps to a certain degree where we were in 2014 when this decision was taken, although for our purposes, there's no material distinction, we would suggest, between the role of the board then and the role of the board now. There are extraneous bits of evidence, perhaps, which inform our understanding of it, but the role, we would suggest, was the same. The oddity, perhaps, of the status of a transfer decision, or a transfer recommendation, as I should properly call it, from the board, when one tries to decide if it's small j judicial or capital J judicial, if I can put it that way, if the court understands what I mean by that, is that transfer and release are two features of the process which are inextricably, in almost every case, bound up together. So the court may have noticed there is a single set of reasoning in the board's decision letter in this case. It doesn't separate out release and transfer. It may be that different questions, ultimate questions, need to be answered in respect of release and transfer. But even then, they're not entirely different questions, given that the protection of the public is paramount in either case. And it may be that a reason given by the board to refuse release, and this is in fact relatively common, that a transfer to open conditions is necessary first to test the prisoner's response, to test the level of risk. The President of the Queen's Bench Division in DSD, which I'm going to have to make some submissions on in a little more detail in due course, highlighted what is perhaps obvious, which is that there are obvious advantages to subjecting a prisoner to regimes of lessening stringency in order properly to test the robustness of the risk assessment. And it's frequently been said that a period in open conditions is usually necessary before the release of an indeterminate sentence prisoner. So a single decision may include findings that a prisoner is not safe for release because he needs testing in open conditions, and therefore a transfer to open is recommended. And to try to separate out, on the one hand, the classic judicial decision on release and what the appellant would suggest is a mere recommendation on transfer in those circumstances is practically impossible. And we'd suggest that it's rather unreal to look at it that way. Nor to deal with another feature of the appellant's case can the analysis, we'd suggest, be affected by the fact that the Secretary of State has a discretion whether to refer a case to the board to consider transfer or not, whereas there are certain circumstances when there's a requirement to make a reference for a decision on release. There's nothing unusual about that in the context of a court or tribunal, of course, because cases typically come before courts because one party decides to refer a matter for decision. Usually that person is a claimant, and the court gets its jurisdiction when a party has referred the matter to it. Doesn't matter how the list comes before the board. It undertakes the decision-making process when it gets there by weighing the evidence and applying the law and giving a decision supported by reasoning, which is subject to challenge on public law grounds. And we say those are hallmarks of a judicial process. So far as release is concerned, as I've just mentioned, there's not always a discretion. There may be a discretion for the Secretary of State to refer more often than is required by statute, but not to fail to refer when required to do so. The other thing to say before I depart from Article 5.4 is that the board is required to operate as a court, and this was something that the Court of Appeal found in Brooke, not only for the purposes of the Convention, but also for the purposes of the common law. Perhaps I can, in fact, I will ask the court to look briefly at the authority. The authorities bundle tab 35 starts at page 1112. Can I take you first, please, to 1115? This is near the beginning of Lord Phillips' judgment. Paragraph 4. Decisions taken by the board determine in a variety of situations whether offenders who've been convicted have been sentenced to imprisonment and have served parts of their sentences are to remain in prison or be released on licence. Well established that this role requires the board shall be and appear to be independent and impartial both under common law and by reason of the requirements of Article 5.4. And then there's a reference again at paragraph 5 to the requirements of the common law. And then if we go on to 1119, there's a paragraph at D under the heading the need for independence and impartiality. Article 5.4 is set out there. Common ground that it's the function of the board to act as the court whose determination is required by the article. The issue raised by this appeal is whether the board has the essential attributes of a court for this purpose. The court must be and be seen to be both independent and impartial. The question is whether the board demonstrates those qualities. It's been common ground the board is required to do so not merely by reason of Article 5.4, but under common law principles. Then if the court can turn please to 1125, paragraph 47, there's a reference here to what my Lord President has described in terms of the progressive change in the role of the board. The role of the board has progressively changed under the influence of decisions of the European Court of Human Rights and consequent domestic legislation from that of an advisory board to that of a court. And there's some, if we can perhaps turn on 5 lines from the bottom, Whatever uncertainty there may be as to the scope of the board's advisory functions, there is no doubt that the major part of the board's duties is judicial in nature. The board has to adjudicate in respect of different types of sentence on whether the continued detention of prisoners is lawful or whether they're entitled to be released under licence. Why must it operate as it does? Well, paragraph 52 on the next page. A court must be independent not only of the parties but of the executive. This is not merely because this is a requirement of the separation of powers, but because the executive sometimes has an interest in the result of the proceedings. So far as the parole board is concerned, the possibility exists that the Secretary of State may be anxious for the board to apply a stricter or alternatively a more lenient test to releasing prisoners than required by the law. So it's a particular feature of this decision-making body, we would say, that the executive is always a party before it. So its independence from the executive and its impartiality are both partly features of the same requirement. I think my Lord President may have drawn a distinction earlier between the need to consider institutional independence and some of the other matters. And we respectfully agree with that. And we say what's particularly important in this context is decision-making independence. It's when the panels of the board take decisions, rather more than the board itself, of course, may have administrative functions. We'll come on to look at in perhaps the same way as Her Majesty's Courts and Tribunal Service may have administrative functions which are different from the judicial decision-making which is undertaken by courts and tribunals.
And as we've just seen, Lord Phillips left to one side advisory functions. And obviously, one characteristic norm of a judicial body is that it's adjudicating on people's rights normally.
Yes.
And one can see why. I mean, it wasn't necessary to categorise the advisory functions in that case, and one can see why a possible difference was acknowledged.
Well, of course, I appreciate that the issue with relation to recommendations on transfer is much less straightforward than the position with regard to decisions on release. And of course, it's going to take me a little while to work my way through all of the reasons why we say it falls to be treated in the same way. We started from the proposition that the two kinds of decision are so intertwined it's impossible to separate them. But
Can I just understand why?
Other matters too.
Why we're pursuing this in such detail? Is this in order to bring the board within the concept of a court or tribunal, as that concept is employed in the Davis case?
Yes, it is. It's as I indicated at the start of my submissions, it's the second part of Mr. Southey's submissions where he said that we don't. Effectively, we, the board, don't make it within Davis at all, even if Davis is good law. It seems to me that is a question almost certainly of law rather than practice. Although quite how far Davis stretches is a matter I'll come on to.
Well, that's what I'm wondering. I mean, at the moment we seem to be trying to establish that the board has certain attributes which would constitute it as a court within some sort of definition of what a court is. And I mean, an alternative approach is to ask, well, why did Davis say that you wouldn't normally make an order for costs against a court or tribunal, and then ask whether that rationale would apply to the board as it actually is.
My lord, yes, and that is, I'm bound to say, the approach that we've set out in our case. I've come to this back to front partly to respond immediately to Mr. Southey's most the later submissions. It seems to me it might be helpful to hear us back to back so far as that is concerned. Partly because I started with the factual context, and these submissions naturally follow on from that. But my lord's absolutely right to say that there's no abstract concept of a court to which the board is to be measured so far as this case is concerned. At least that would be our submission. The question is whether it should be treated as falling within the sorts of bodies which Davis treats as or refers to as courts. Should the parole board be one of those?
Yes, well, that's what I'm thinking. If you look at Davis and its historical context, it was in a pre-human rights. Well, it was in a dates from an era before tribunals had been reconstituted to judicialize them, and it may not have taken quite as strict an approach to the attributes of a tribunal or a court as you're now trying to establish that the parole board meets.
Well, one of the other reasons why I'm doing it in this order is to identify for the court what we say are the important aspects of the board, which at least bring it in the arena of judicial decision-making bodies. Hopefully, then, when I come to deal with Davis, you'll have firmly in mind what we have to say about issues such as independence and impartiality and so on, so far as the board is concerned.
Just pursuing the point we've just been discussing, is it not sufficient to establish whether or not the particular function invoked in the litigation in which costs are claimed was judicial? One doesn't have to, as it were, do a panoramic view of everything that the parole board could possibly do, but simply whether it falls within a category of judicial or, I think, quasi-judicial for the purposes of the Davis rule, when it's making the decision which is disputed and challenged in the particular litigation.
I'm sure my lady's right that it won't be helpful for me to try and look at everything the parole board might conceivably do, including matters which are not in issue in this case. It's not quite so easy to identify what is necessarily the decision taken in this case in circumstances where we have a release and a transfer referral. We have an appellant who argued only in relation to the transfer orally in front of the High Court, but we have grounds of claim which deal also with the question of release. And so what I propose to do, unless the court tells me it would be helpful to do it differently, is to look at release and transfer and the way in which they have been operated in the context of this case and confine my submissions to that. Most courts and tribunals deal with the same sorts of matters, if I can put it that way. Coroners hear inquests, tribunals hear disputes in whatever their specialism is. We're broadly speaking in the same sort of territory as a tribunal, in that there's only a limited number of matters that the parole board looks at.
Functional test. It's more of a function. It's the function of adjudication, one of impartial decision making, impartial and independent decision making.
My lady, yes, we'd be content for it to be described in that way. My lords and my lady have some fairly detailed submissions in our case about the requirement of independence and indeed the appearance of independence, which is also a matter I'm going to come back to in our case, and I don't propose to go over all of those. Can I just flag up another way in which the courts have looked at what the parole board does, and that's a passage from DSD in which the president looks at, so I'm just looking for the reference, it's tab 39, page 1185 is the start of the report, but page 1236 is the passage that I asked the court to look at. And it's in, so DSD involved more than one issue. One of the issues was about the open justice principle and the extent to which parole board proceedings should be open and to what extent they should be open to the public. And at paragraph 171, the President considered the open justice principle. It's the bottom of page 1236. He said that the principle doesn't apply to tribunals which are not courts, and Mr. Sheldon, that's Counsel for the Secretary of State, submits that the board is not a court for these purposes. He does accept it's a court for other purposes, including the application of Article 5.4 of the Convention. That submission receives some support from the fact that the board has inquisitorial functions, deploys a degree of informality, and does not apply strict rules of evidence, and that between 1968 and 1997 its function was to advise the Secretary of State rather than make binding determinations. However, matters have moved on, and just to pause there, we'd respectfully suggest that inquisitorial functions are in no way inconsistent with being a court or tribunal, nor indeed is a degree of informality, and many tribunals seek to deploy a degree of informality. Rules of evidence will vary between different kinds of courts and tribunal. And what happened between 1968 and 1997 provides very helpful background, but it doesn't tell us what the status of the board is now. But the President, I think, recognises that. He says matters have moved on. The critical question is whether the body at issue exercises the judicial power of the state. It's another way, another formulation which has been identified as looking at whether a body is a court or tribunal. In the case of the parole board, that question must be answered affirmatively, relying on inter alia and Brooke. And he says the judicial function of the board is to determine whether a prisoner should remain confined after the expiry of his minimum term. Adjudications upon matters of individual liberty are paradigm examples of the exercise of a judicial function. But of course, that passage only takes me so far. I accept that because he doesn't go on to look at questions of transfer as well. That's it's helpful so far as it deals with release, but it doesn't go on to deal with transfer. The expression, the judicial power of the state, my lords and my lady can see, is taken from a case called P and Liverpool Daily Post and Echo newspapers. Which was, and I won't ask the court to look at it, was a case which considered whether a mental health review tribunal was a court for the purposes of contempt of court. But that's where that expression comes from, but I don't propose to take the court's time by looking at the case separately. The last case that I want to look at before coming back to the board itself is a 1979 case called Trapp and Mackey, which is 63, Authorities Bundle, tab 63, page 1705. And it's a case in which the House of Lords looked at a different issue. That's the availability of witness privilege. See, what we've tried to do is look at cases looking at different aspects of courts and tribunals. This one is a little old, I concede, but the House of Lords approach in this case was looking whether witness privilege was available at common law, noting that it was available in relation to evidence given in a tribunal recognised by law. The relevant passages start at 1716, please. This is within the opinion of Lord Fraser. And right at the top of the page, he says that consideration of the cases shows that provided the tribunal is one recognised by law, there is no single element, the presence or absence of which will be conclusive in showing whether it has attributes sufficiently similar to those of a court of law to create absolute privilege. It's not essential that the tribunal itself should have power to determine the issue before it. My lords, my lady will apprehend, we say that may be of some significance for the purposes of this case. And he goes on to say, down by C, that some other cases Dawkins and Barrett show that absolute privilege may apply if the inquiry is a step leading directly toward determination of an issue by the authority who appointed it. In each case, the object of the tribunal, its constitution and its manner of proceeding must all be considered before the question can be answered. And Lord Diplock, this was a case about a dismissal of a headmaster from a school, and the way that the dismissal was considered was that a local inquiry was held before a commissioner appointed by the Secretary of State. The commissioner's conclusion wasn't binding. The way that it was put by Lord Diplock, your note 383B, the decision nevertheless in practice had a major influence on the final decision. And Lord Diplock observed that, perhaps I can take you to it, 1711, right at the top of the page. It may not be out of place to mention that when your lordships are sitting as an appellate committee of this House or as the judicial committee of the Privy Council, the result of your deliberations is a report of your collective opinion in the one case to this House and in the other to Her Majesty and Council. In strict law, the opinion so reported doesn't become binding and authoritative until agreed to by this House or by Her Majesty and Council, as the case may be. And the approach taken, this is just above C, where the report of a tribunal, though not necessarily decisive as a matter of legal theory, nevertheless in practice has a major influence upon the final decision, the same considerations apply to such a tribunal as those that weigh the balance down in favour of absolute privilege. My Lord, I don't suggest that one can read across directly from this case to the present, but it's another illustration of the balancing act that needs to be undertaken in reviewing all of the circumstances in which a body, a decision-making body, undertakes its functions. And the function itself, my Lady Arden identifies, may be the starting point for the inquiry. Now, one of the matters that the appellant says is significant and shows that the board should not be treated as a court is the existence or operation of what is described as its litigation strategy. And the court was taken to the strategy, which is it's in the core bundle of authorities. I'm so sorry. It's in the authorities bundle, tabs 6 and 7 of the 2013 strategy is at page 398. Now, what is the litigation strategy? Well, it's described on the board's website as a guide for legal practitioners about how the Parole Board handles litigation and the way it deals with judicial reviews. And we suggest that's a fair description of what it is and why it exists. It hasn't been possible to identify precisely the reason for its introduction in 2013, but it appears to be in the context of the evolution of the board's role and a growing recognition that judicial decision makers ought not generally to participate in judicial reviews of their judicial decisions. However,
it would suggest there was rather a lot of judicial review going on. Can you give us any figures about the number of cases in which the board is involved? Maybe you haven't had time to think about.
I heard your question this morning, and I've caused some inquiries to be made. I don't yet have answers in sufficient detail. I'm sorry to answer you, but not to be able to answer you. I'll do it first thing tomorrow morning, if that's all right, ma'am.
When it's convenient. Thank you.
Thank you very much. What the strategy might fairly be described as, we would suggest, is an attempt by the board to convey to stakeholders in general, but legal practitioners in particular, what approach it takes to litigation. It allows advisors to see how the board approaches judicial review and advise their clients accordingly. it explains, and this will be important for legal advisors, the position on costs and the reliance on Davis. That's not an explanation of why the strategy exists, of course. It's information provided as part of the strategy to legal advisors, and important information nonetheless. The court will see the distinction that is drawn between in this case, some judicial decisions and administrative decisions and private law claims for damages. And of course, there's a difference in nature between the two. I've indicated that my Lord Legate has a question, I think.
Can you just help me with when the board is potentially liable in damages? Because that may be of some relevance to its.
Yes, there have been a series of cases about delays, and there was at one point a backlog in hearings, so that prisoners who were ready to be considered for release weren't able to get a hearing simply because the board didn't have sufficient capacity. And there were a number of cases, my friend was I think involved in some of them, where damages were claimed by prisoners. So their damages arising out of essentially administrative difficulties on the part of the board, not arising out of judicial decisions, if I can put it that way.
But would these be damages claims under Article 5.5 of the Human Rights Act?
Oh, I think that's right. Something I think wants to say something. You may be able to.
Yeah, my lord. Sorry, just for assistance, my lord may remember, in fact, the Faulkner case, which was established the principles to be applied when the parole board was in breach of Article 5.4 because of delay, and my lord will remember you get you get a higher level of damages if you can prove you would have been released, but you can get damages just for frustration, basically.
Yeah.
Yes.
And the point was that Article 5.5, if I remember correctly, stipulated that damages had to be awarded.
That was part, but the case law of the Strasbourg court, as my lord may remember, also consistently showed delay was regarded as something that should be compensated with damages.
Yeah.
I hope that answers my lord's question, and it explains perhaps the difference between administrative decisions and damages claims on one hand and judicial decisions on the other hand. We have the slight anomaly in the 2013 strategy that decisions about early release and transfer to open conditions are on the list of those decisions which won't normally be defended. There's a reference to other types of judicial decision which will be defended. And I have to say that we've been unable to establish precisely why that distinction was drawn. We accept it appears somewhat anomalous. It's plainly been corrected in 2019 to say that judicial decisions will not be defended. But the important distinction is that the board will not seek to defend judicial decisions, which means it remains neutral in respect of those challenges. Now, we say that for the board to give a transparent indication of the broad approach it takes is perfectly proper. What it doesn't do, and rightly so, is give a conclusive answer as to whether any given case will be defended. And by way of example, the appellant says that it's instructive that in the John Warboys litigation, the DSD case, the board did participate. And I should address that submission. It was a case in which unusually the board did participate in a claim or judicial review of a decision on release. It's at tab 39 in the authorities bundle. Starts at page 1185. If we can look first, please, at 1196. The President introduces the decision, and at paragraph 3, he says that as far as we're aware, this series of cases is unique for a number of reasons. First, never before has a decision to direct the release of a prisoner been challenged. Because the only parties to a hearing before the board are the Secretary of State and the prisoner, it follows that never before has judicial review been mounted by anyone other than a party to the proceedings. Second, there'd never previously been a challenge to Rule 25 about making information public. And he concluded that the novelty of these challenges serves to emphasise its wholly exceptional features. And it was those wholly exceptional circumstances which made this an appropriate case for the board to participate. And precisely because its involvement was unusual, the board expressly felt it right to explain its position in participating. And that's page 1216, to which you were taken earlier this afternoon by my learned friend. And I want to come back to it because I respectfully submit you were given an unfortunate paraphrase which was wrong. So paragraph 84, the board's first point was that the release decision is a species of judicial decision which speaks for itself and in the ordinary course does not require active defence. Position is analogous to judicial reviews of statutory tribunals which are not generally defended by the tribunals themselves. Well, that's absolutely consistent with the submissions that we make to this court. What the parole board recognised was that in the particular circumstances of this case, it was necessary, and this was the misparaphrase, if I can put it that way, firstly, to address important issues of broad approach, and secondly, for the sake of clarity of the parole board's decision on such matters, and I pause there, it was necessary to address some of the specific criticisms. And my learned friend suggested that what the board had said was that it had appeared in order to address the specific criticisms. And that puts it the wrong way round. It was decided that it was necessary to address the criticisms in order to perform a couple of functions. That's addressing the issues of broad approach and for the purposes of clarity. And what we say is that this case is actually a good illustration of the board's approach. It's not inconsistent with it. It highlights it. It highlights that the board's practice is not to defend judicial decisions, but there may be individual cases, this was a wholly exceptional one, which made it appropriate to appear and participate. It was sufficiently unusual that the board felt the need to explain its participation to the court, and having participated, absolutely no question, but it would be liable to pay costs if it lost. What it doesn't do is, as the appellant suggests, show that the board clearly does have interests. That's the way it's been suggested once or twice, that the board has strategic or corporate interests. Well, in its judicial decision making, absolutely not. The board's only proper interest in relation to a judicial decision is the proper administration of its statutory role. It simply does not have its own interests and strategic aims in terms of judicial decision making. It may do in relation to the commissioning of an IT system or the recruitment of sufficient members, but not in terms of judicial decision making. And in those circumstances, neither the existence nor the terms of the litigation strategy could possibly suggest that the board is not a court. And the option to concede, just to finish up, my lords, my lady, I'm conscious of the time, the option to concede at the outset is entirely consistent with it. There's nothing mysterious about it, to address the perhaps rather unfair description given by my learned friend. If presumption, correspondence or ground an obvious error, so if somebody's made a mistake as to previous convictions, or there's somebody who doesn't apply the statutory test and it's entirely obvious, the proper course may well be to concede that the decision is flawed. Again, that's not in pursuit of a strategic or corporate interest, it's in pursuit of the interests of justice. So we respectfully suggest that the existence of the strategy doesn't have the effect on your that the appellant suggests that it should. My lord, my lady, it's 4 o'clock. I don't know if that's a convenient moment for me to stop.
Yes, certainly. Thank you very much, Mr. Collins. We'll adjourn there for the day and we'll resume at 10:30 tomorrow morning. Thank you very much.